President Trump, in this video, I am going to give you an example of why I said there is absolutely no doubt whatsoever in my mind that your hush money trial was the result of a request by Joe Biden. However, I want you to see how Joe Biden actually works, because I think you're harming yourself, as are other people who are accusing the entire Justice Department. That's simply not the way Joe Biden works. Trust me. I'm going to give you an example. In the lower corner of the screen is a document. And the reason I put that document there is because it's very important, because that document proves that what Joe Biden had his son, who at the time was the Attorney General of the state of Delaware, Beau Biden, do, was actually criminal in and of itself. I'm going to take you back to 2008. On January 3rd of 2008, Joe Biden ended his 2008 presidential nomination campaign because of his dismal showing in Iowa. 15 days later, on January 18th of 2008, I posted a YouTube video talking about an incident between myself and Barack Obama that occurred in 1999. 16 days later, on February 4th of 2008, the Delaware Attorney General's office obtained a grand jury indictment charging me with theft. And they said that the theft occurred at the Roadway Inn on Memorial Drive in Wilmington, Delaware. What Beau Biden did was have one of his deputies go to a grand jury and accuse me of something that they knew for a fact never happened. The only reason I can fathom why this took place and why Joe Biden had it done was because he was positioning himself eventually to become, which he successfully did, vice president for Barack Obama. After this indictment was handed down, the Beau Biden Attorney General's office for the state of Delaware claimed that they actually mailed a copy of the indictment and the warrant to me, even though by that time my address was publicly out on the internet, because people made a point to make sure that was the case. Interestingly enough, the alleged notice and copy of the indictment and warrant was returned to the court. And it was returned to the court because it didn't have a mailing address on it to begin with. I became aware of this warrant and indictment in April of 2008, at which time I immediately contacted Newcastle County Sheriff's Department, left a voice message because that's all I could get to. And even though I left all of the contact information, the warrant information, everything, never once was it responded to. I was eventually arrested in Washington, D.C. on June 18th of 2008, and it was widely reported that it was on an outstanding warrant from Delaware. That too was not true. In fact, Joe Biden, who was still Senator Joe Biden at the time, had used his contacts with the U.S. Attorney for D.C. Office, and at that time it was Jeffrey Taylor, to arrange for a very public arrest of me at the National Press Club. But the problem is that Delaware was contacted when these arrangements were being made, and Delaware specifically notified D.C. authorities that it was their policy when someone was picked up in reference to a charge in Delaware, in the DC area, of such minor consequence, that Delaware preferred that the court advised the individual to leave the court and head straight to Delaware and turn themselves in. And that's what Delaware authorities had requested DC authorities do. But DC chose not to do that. Instead, the U.S. Marshals and Metropolitan DC Police made a big scene at the National Press Club in arresting me. And they claimed that they were arresting me on an outstanding warrant. They were asked to provide a copy of that warrant. At the time, they said, oh, they left it downstairs in the car in the garage. We get to the garage, there's no warrant in the car. We get to the precinct, there's no warrant at the precinct. The reason there was no warrant anywhere is because they didn't have the warrant yet. They hadn't even requested the warrant until after they had taken me into custody and I appeared before a U.S. Magistrate Judge the following day. Fast forward, I was arrested, I went to Wilmington, Delaware, I was released on bail, and immediately the Delaware News Journal, which is Joe Biden's hometown paper, started publishing articles about me and my arrest. And from the very first article, they stated that I was charged with paying for a 3-week hotel stay with counterfeit money orders. Not only did they make that statement as a statement of fact, they actually stated in their article that that information was according to state trooper reports and the court case file itself. The problem with that is that there's no report of any such thing taking place, nor is there any mention of any paying for any hotel stay for 1 day, much less 3 weeks, with counterfeit money orders, nor is there any mention of paying for anything with counterfeit money orders. The document in the lower left corner of the screen is an agreement that I signed with the owner of the Roadway Inn, who approached me while I was staying there, offering to cash money orders that I had received for a fee of $300. I didn't really feel comfortable with it, but after he assured me it was okay, we made this agreement. And on this document lower corner, it clearly states, and I wrote it and signed it, that 1, I don't want any cash from the cashing of these items until such time as they have cleared the bank. And 2, that in the event they do not clear the bank and this individual is charged any type of return fees by the bank, that I would pay those fees. None of this was provided to the grand jury when they went to get an indictment against me, even though they were fully aware of it at the time. Nothing on there states anything about paying for a hotel stay. Now, turns out that Joe Biden went through his son, Beau Biden, to get this indictment and get this charge. Then, Senator Joe Biden used his Senate office and individuals within the Social Security Administration to, 2 days before the press conference and before my DC arrest, send me a letter stating that my disability was being terminated because there was an outstanding warrant for fugitive from justice for a parole or probation violation. And it listed the Delaware warrant, but it claimed that it was for parole or probation violation, which was not true either. Doesn't matter that nothing the Delaware News Journal published was true. It doesn't matter that Joe Biden's son used his office to get an indictment for a charge that they knew did not ever occur, and actually withheld documents and information proving that fact from the grand jury, was illegal. Doesn't matter that it was a violation of state law, federal law. It was a violation of the state bar. It happened. And here we are in 2024, and to this day, no one has had to be responsible for it. What they thought was that I was going to feel pressured because of my previous past. They thought that they were going to scare me or pressure me into pleading guilty to a charge, to a crime that I never committed and that never actually occurred. What they did succeed in doing is costing me well over $20,000 in expenses and attorney's fees fighting them and defending myself, which is something I do if I'm accused of something I haven't done. My entire life, if I do something, I own it. But if you accuse me of doing something I have not done, trust me, I will fight tooth and nail to prove just that fact, that I did not do it. In this particular case, the Deputy Attorney General, Susan Dwyer, in August of 2008, right after the judge set a scheduling order which set my trial date for September 11th, no less, of 2008. The Democratic Convention in Denver was getting underway, or about to get underway in Denver. And I had my attorney point out to the Attorney General's office about this document that you see in this video, which they had, but they never turned over in discovery or even acknowledged knowing about it. Now, 5 articles by the Delaware News Journal between June and August of 2008, at the behest of one Joe Biden, published outright false, libelous lies, accusing me of paying for a hotel stay with counterfeit money orders that never occurred. And despite being asked to retract and apologize because it's a Gannett newspaper, they refused to do it. The reporter was steadfast. Oh, it's in the court file. No, it's not. Wasn't then, isn't now. Wasn't in the troopers' reports, wasn't then, isn't now. Just prior to the convention starting, Ms. Dwyer sent my attorney, who was Francis Farron, an email asking him to propose a plea bargain, saying that they would drop it to a misdemeanor if I pled guilty with probation for 1 year. I immediately refused the offer. The response from Ms. Dwyer to my attorney was, is Mr. Sinclair really going to decline a misdemeanor plea and risk a habitual offender charge? Making clear that if she convicted me of theft, she was going to go after a habitual offender charge in Delaware. Mr. Farron forwarded me the email and I responded. And my response to Ms. Dwyer was, Ms. Dwyer, yes, I absolutely am. Because I'm not pleading guilty to something I didn't do, and I have no problem going to court. Needless to say, just as the convention was getting underway, the Delaware Attorney General's office dropped the charges, decided not to prosecute, giving the reason insufficient evidence. But they had done the damage. And it was all at the behest and the urging of Joe Biden. Joe Biden will definitely use prosecutors, reporters to do his bidding. But I want you to understand exactly how he goes about doing it, because you can nail it. Believe me, it took me a while to document every single thing, but every bit of it's documented. And this is just one example. I'm going to give you another one in the next video clip. When I tell you no one knows how Joe Biden works and how he goes about doing these things better than I do, I'm not exaggerating to you. And when I tell you you were not the first, are not the first, to be targeted by his use of, and I'm using your phrase here, lawfare, this is an example of demonstrating to you I was serious. But it gets worse, because the next example is going to show you exactly how he used Alvin Bragg to prosecute you for hush money payments, when in fact there was no law broken.